All right, great. Thank you, Kelly. And hello, everyone. We got a nice dreary Thursday here coming off of lunch. So I'm the lucky one that tries to keep everybody awake here for the next hour. So I do have with me Mary Beth Clark, as Kelly had mentioned. Mary Beth's going to join us later to give us a good story on a case. Yeah, as Kelly had mentioned, I'm going to try to hammer through as much as I can. If you do have any questions, just throw them in the chat, and I will try to see if I can get to this all quickly enough, and I can keep myself from talking too much to get us done within the hour. And then hopefully we'll have some time to answer some questions at the end if there are any. And if I don't get to all of them, I'll try to answer them, maybe in a Word document and get them to Kelly and try to have her circulate them after the fact then. Kelly did email the PowerPoint, which I see she just put in the chat there. Kelly had emailed the PowerPoint in advance. If you get a chance to check that out, that way you can make any notes as you might. Now, just as a disclaimer for anybody who, I think this is the third year now that I've been doing this session for VOCA grantees. And just as a kind of disclaimer or a caveat here before we get going, this is going to look pretty similar as far as the information we cover substantively to the last 2 years worth of sessions. Realistically, there's not been an awful lot of new developments in recent times. We did have one new development, which led to one new slide here, but by and large, if you'd been in on any of the sessions the last couple of years, some of this might look very familiar, and I'll apologize in advance for that. So to get us going, what are we going to talk about today? We want to talk first about spotting important issues that you're likely to encounter if you're working with victims of domestic violence and the intersection between that domestic violence and housing. We'll talk about the Violence Against Women Act, which you'll hear me refer to as VAWA. I try to stay away from acronyms as much as I can, but I'm going to be using VAWA a lot today just for time's sake. So please make a note of Violence Against Women Act, VAWA, which applies to subsidized housing. We'll talk about what to do in market rate or private housing, where you have an individual working with a private landlord, which is a scenario in which VAWA does not apply, and what options you might have available if you're trying to help someone in that scenario. We'll talk about nuisance ordinances and crime-free ordinances. We'll also talk about a recent change to some rules of civil procedure related to domestic violence victims. Now, a couple things that I'll note up front here is, honestly, like, if you don't take much away from this session today because I'm breezing through things, or you just don't see housing pop up a lot, come back to this slide, please. The three things that I have listed here, to me, are honestly like the three most important things I think you could take from today's discussion. One is that if you encounter an issue involving housing, I think that you should feel free to contact whoever might be a local resource for you who might do housing with any one of the plans provider programs. We also have a plan housing law group, and we have a listserv, which I've linked to there. If ever you feel the need to post a question to all of Plan's housing law group throughout the state, you can contact Hank Leone with to Plan if you wish to be added for some reason to that group. But again, big thing for me is, if you're not familiar with housing and you're not going to take probably too many things that you'll remember from today's session, just know that if you do come across an issue, the housing law group's always been very willing to try to help individuals, which I think Mary Beth can talk about later when we talk about a good case in collaboration between attorneys throughout the state. So please reach out to a housing law advocate if you are in need of assistance. Also, I have there links to two different National Housing Law Project websites, which are just great resource databases for anything related to victims of domestic violence and housing. I didn't bother, frankly, to provide any materials, because I would just literally be copying everything from those websites and trying to provide them to you. So I have the links there. If you go to those web pages, they're very user-friendly. The National Housing Law Project is essentially the nationwide organization that we consider to be the go-to for everything housing related, especially with relation with relation to subsidized housing, because of that involving federal programs. So the National Housing Law Project has a resource center for just general protections and working with victims of domestic violence. also has one about dealing with nuisance and crime-free ordinances. And as I had mentioned before, last thing we'll try to wrap up with then is having Mary Beth review a case example on a case that she had worked a couple years ago. So I'm going to jump right into VAWA. I'm going to talk first about historical background and what's the current status of VAWA, because there's a little bit of confusion surrounding its current status. So just know that, VAWA is a law that protects victims of and threatened victims of domestic violence, dating violence, sexual assault, and stalking from being discriminated against by certain housing providers because of the abuse that's committed against them. Congress passed this initially back in 1994. It's since been expanded with VAWA 2000 and then the DOJ's Reauthorization Act in 2005. On the next slide here, talk about the more recent developments. The most recent reauthorization of VAWA happened back in 2013, which I have VAWA 2013 reference there and the site for it. That reauthorized most of the programs, although most of the congressional authorization for the grant programs under VAWA expired and sunset on December 22nd of 2018. That said, the housing protections from VAWA 2013, which go all the way back, those housing protections contained in VAWA do not have any sunset provisions such as the authorization for the grant programs do. So therefore, the housing protections of VAWA did not expire when the authorization for the programs expired. So as we're sitting here talking today, VAWA's statutory housing provisions and everything related to them still remain in effect. So that is kind of this misnomer, as some folks might see that, oh, VAWA expired at the end of 2018. Is it still good? We still see questions posted to the nationwide listserv every now and again about that. And there's a lot of good material out there, especially there's some letters from the DOJ that specifically make it clear that the housing protections still remain in effect today and still are active. So now we want to talk generally about how VAWA applies, and I have your citations there if you need to get down in the weeds on VAWA. But just know that again, it protects these individuals who are survivors of domestic violence, sexual assault, dating violence, stalking, who live in federally assisted housing. VAWA does, and I'm going to talk about that and flesh that out a little bit more here in a second. But VAWA does not apply to market rate or private rental housing unless there is a federal subsidy involved, which I'll get to again. The law applies to a survivor, whether it's an actual or perceived survivor, regardless of sex, gender identity, sexual orientation, disability, or age. It also protects lawful household members. So there are kind of these unique scenarios where, say, like the head of household may be the abuser, but the person who's on the lease but is not technically the head of the household is the victim, and they want to assert VAWA rights, but they're not the head of the household. VAWA covers everybody in the household to specifically address those situations. Something I'll note up front here, which is, I'm probably telling you something that you already know, but it does become important later. I'll loop back around on this when we start talking about market rate housing and what to do. But the overwhelming majority of victims, domestic violence victims, are female. However, VAWA protections, of course, are gender neutral, so they apply both to men and women victims of domestic violence. But do note that, and we keep this in mind, that the overwhelming majority of victims are female. We'll come back to that when we start talking about private housing. So now, to what programs does VAWA apply? And I saw Val West, my friend Val, I saw that she had posted a question here. So Val, hopefully I'll be answering this here. So to what programs does VAWA apply? Basically, the answer is almost every single one. It may be every single one, but at least almost every single federally subsidized program, VAWA covers it. So I have listed here the vast majority of them. I have highlighted here for you all what I kind of call the four major programs that I think if you are working with somebody in subsidized housing that you're likely to encounter. So that's public housing. That's housing that's owned and operated by the housing authority. You might typically hear that referred to as project housing. Public housing, VAWA applies. Section 8 housing choice voucher program. Now, We hear the term Section 8 thrown around a lot when we talk about subsidized housing, and I think folks, refer to Section 8 as kind of generally covering all of subsidized housing, and it does cover a large portion of it. It's certainly not everything, but when we're talking Section 8, it is important to note that there is a distinction between two of the major programs when it comes to Section 8. So you see there, the first one is the Section 8 Housing Choice Voucher Program. That's a tenant-based voucher where the tenant actually gets the voucher from the housing authority and then goes out into the community and looks for housing and rents from a private landlord. And then the housing authority, vis-a-vis the federal government, then subsidizes the tenant's rent out in the community. That's a very desirable program. That's the program where, if somebody has a voucher now and they stand to lose it, you want to do basically everything you can to try to protect it, because that's the most desirable program. They usually have the longest waiting lists that are usually years and years long, if they are even open to taking applications, because their wait lists are so long. And even if they do take applications, it's usually some sort of like a 3-day window with a lottery program. If you're ever working with somebody with a tenant-based Section 8 housing choice voucher, that's a big deal to try to do whatever you can to protect against them being terminated from that program. Now that differs then from the project-based Section 8 program, which, as its name suggests, that's project-based assistance. So those are places that are owned and operated by private landlords, usually major conglomerates that are in housing development and what have you. And they have a direct line in one form or another to the federal government through the Department of Housing and Urban Development, HUD. And they subsidize apartments in their complex for anyone who lives there. So a tenant might not have their own Section 8 housing choice voucher, but they can get the same assistance, same rental assistance, if they go and apply to one of these properties where the property has project-based Section 8. And then it's just that the voucher doesn't move with them. It's attached to the property, the project. So they're not able, if they end up being evicted or if they end up moving out, they don't get to take the Section 8 with them. So those are the three major HUD programs that you're likely to encounter if you're working with the victim of domestic violence and housing, subsidized housing. I also highlight down below, now for any of you who are in more rural areas, you might run into with the Office of Rural Development and the U.S. Department of Agriculture. You might run into some of the rural housing programs. But beyond that, there's a Treasury program. It's kind of one of the, I guess, maybe little known facts about subsidized housing in America. Through the Department of Treasury and through the IRS and the tax code, they created many moons ago a low-income housing tax credit program, which is basically, it's very complicated, but basically for housing developers, they can go and get tax credits from the government to help them with funding development of subsidized housing. And then in exchange for those tax credits, they have to maintain a level of subsidy at their properties. Now, it's not the same as the HUD programs, doesn't operate the same way. And I'll save you guys all the hassle of knowing the difference, but just know there is a difference. But the low income housing tax credit LIHTC program is actually now, it's become in recent years, the largest stock of subsidized housing in the country. It used to be public housing was our largest stock, but that there's been a movement away from public housing and HUD funded public housing and into this low income housing tax credit program and developing through private developers subsidized housing. So I have a little note there that if you're ever dealing with somebody who mentions that their rent is subsidized, but they're not sure exactly what program they're in, one of the dead giveaways for LIHTC is that the Pennsylvania Housing Finance Agency, which oversees the LIHTC program here in PA, there's a requirement that every LIHTC landlord have a lease addendum, a one-page lease addendum attached to every LIHTC lease. So if you're working with somebody and you don't know exactly what kind of housing you might be dealing with, one of the things you look for first is to see if there is a lease addendum, a LIHTC lease addendum, and that'll give that away if you find that. So those are your major programs to which it applies. Furthermore, what does it do, right? When we talk about, like, if we actually dig into a case, like what does it actually do and what protections does it provide? So what VAWA does is provide the following rights to victims. So they have the right to not be denied admission, not be evicted, not have a Section 8 assistance terminated because of violence committed against them. So for instance, a housing provider can't deny an applicant housing because of domestic violence or sexual assault, stalking, dating violence, including if the survivor has a criminal history or a poor credit history, which is directly related to the violence. We see this a lot in, say, public housing, where they're renting from the housing authority and there's an incident of domestic violence involving the abuser who is not on the lease, and the housing authority turns around and sends an eviction notice and says, hey, you know, we got a police report saying that there was this incident there, and we see that there was this abuser was named as being there. We're going to terminate your lease because we think that he's living with you illegally, or there was damage done to the property, and so we're going to evict you for the damage that was done by the abuser, or we're going to evict you just simply because of criminal activity having occurred in the unit, all of which would in and of themselves, they would all be generally violations of a lease, which would warrant the housing authority moving forward to evict. However, because of VAWA, if we run into that scenario in subsidized housing, VAWA provides protections to the abusers. They can utilize this form that I'm going to talk about in a second to then try to rebut the housing authority's presumption that they should be able to move forward with eviction. So another thing, they have a right to be provided with a notice of their rights under VAWA. We see subsidized housing providers, frankly, in my experience anyway, go out of their way to make sure that they're providing these notices to tenants so that they know that they're not running afoul of VAWA. So you have this form HUD 5380, which I'll come back to later on when we talk about resources, but there's a form that spells out the tenant's rights under VAWA that the housing provider has to provide to the tenant. There's also a VAWA self-certification form, the form HUD 5382, which is a self-certification form that the tenant can utilize to explain to the housing provider that they think that there's been an incident of domestic violence, which should provide the coverage of VAWA and protect them from being evicted or from having their assistance terminated. So this is these notices are required to be provided to them by the provider, the housing provider, when they're admitted into the program, and or when they're denied admission or assistance, or when they receive an eviction or termination notice. That's why I say, again, my experience, like say our housing authorities here, I know that they provide these notices up front to the tenants when they're admitted. And then when they send out eviction notices, they also provide these notices as well, just to really make sure that they're covering their bases. The tenant can request that an abuser be removed from the lease and housing where it's applicable. There are, of course, some kind of hoops to jump through and some circumstances that need to be met, but they may be able to bifurcate their lease and remove the abuser. For participants with a housing choice voucher or even in public housing, they may be able to move with continued assistance, right? They may be able to be relocated if they are trying to seek refuge and try to stay away from their abuser. I have some more here on the next page I'll run right into. They can seek an emergency transfer to another unit in the same program and or another federally subsidized program. They can stay in the unit even if there's been criminal activity that's directly related to the violence, right? So we talked about that public housing scenario. They're entitled to strict confidentiality of any information related to the domestic violence incident. So if they do fill out that form where they spell out on the self-certification form what abuse has been committed, they're entitled to strict confidentiality of that information. And then, as I said, I mentioned earlier, the self-certification form for HUD 5382, which is available in 11 different languages, by the way. That, you know, if they can just simply self-certify, they don't necessarily have to have a PFA. There doesn't necessarily have to be police involvement with police reports. Now, that said, if there is some sort of conflicting information provided that such that the housing provider might have questions to be asked as to the veracity of the tenant statements, the housing provider can request additional documentation be provided. But the baseline is that the tenant need only necessarily self-certify to be able to pull themselves under the protections of VAWA. Now, there are some limitations to VAWA. So in particular, these couple of things I'll mention here. So number one is that the housing provider can still evict or terminate assistance for violations, which of course are not covered by VAWA, right? So, if you have a scenario where the tenant has an unauthorized occupant living in their unit and has had that unauthorized occupant in there for some time, and there's an incident of domestic violence, and the housing authority, as a result of that, finds out about the unauthorized occupant, if the housing authority tries to evict or terminate assistance, they wouldn't be able to evict or terminate assistance based on the incident itself and anything related to the domestic violence. But if they uncover that there's some other violation, they would, of course, be able to move forward with trying to evict the tenant, and VAWA would not provide protections to those incidents which are not covered under VAWA, of course. So they also can still evict under what I'll call like the direct threat provision or exception to VAWA. But I will say, if you look at the language here, that they have to be able to show if they're going to deny assistance or deny the protections of VAWA, they have to be able to show that there would be an actual and imminent threat to other tenants or staff. And they have to be able to show that allowing the survivor to remain poses a physical danger that is real, not a perceived danger, but a real danger, that the danger would occur within an immediate time frame, and that the danger could result in death or serious bodily harm to tenants or staff members. So as you can see, that's pretty severe language. That's a pretty high burden for a housing provider to meet. I can't say that I've personally ever encountered anybody trying to utilize that, but just know that it is there as a possibility if you try to assert VAWA protections. The other thing, and as I say here, importantly there, HUD's emphasized that this exception can only be used as a last resort. So the house, it's kind of like if anybody's ever worked in the area of reasonable accommodations, it's kind of similar that there should be some, kind of interactive process where you're talking with the housing provider about, is there anything else we can do? Can we move into a different unit? Is there any way we can try to work around this before the housing provider comes right on out and says, nope, there's nothing we can do. We have to move forward to get rid of this person under this direct threat exception. Now, sorry, go ahead. Yep.
If I could just interrupt, I'm going to launch the first of the CLE poll boxes. Presenters, you don't need to worry about responding. You're good. I will leave this up for 2 minutes. All attorneys requesting CLE credit for your participation today must answer both questions. This is the first of 2. And Matt, please feel free to continue whenever you're ready.
Great. Thank you, Kelly. Yes. So now back to, I think this should be, our last slide on this is just forms to know that I want to make note of. And like I said, these are all readily accessible, online in any of those materials from the National Housing Law Project that we had referenced earlier. So you got the HUD 5380, which is the notice that's provided at the time that they move in or at the time that they're being evicted, to notify the tenant victim of their rights under VAWA. 5381 is there's a model emergency transfer plan. So, again, any subsidized housing provider has to have a plan in place for potentially transferring a victim of domestic violence in an emergency situation. 5382 is the certification. That's that self-certification form that we talked about. And then 5383 is an emergency transfer request form. That are all HUD generated forms. Now, I put a note on here that if ever you go looking for these forms, the current versions that I am aware of that I've found of most or all of these forms all say on them that they expire sometime in 2017, but just know that they are still valid because, again, we do still have the protections of VAWA in place. And as I understand it, I can't say I've looked closely enough really to say this with the absolute certainty, but as I understand, I don't think the forms have changed much over the years. If anything, the only thing that's changed is just the dates on the top when they say that they're good for when they reauthorize them. But the forms themselves, I think, have all remained pretty constant throughout the years. So now, that's subsidized housing, and that's where VAWA applies. And so if you recall back to what I mentioned earlier, VAWA does not apply to private housing, market rate private housing for private landlords, private renters, private tenants. So now I will say that by and large, if we're dealing with an incident of domestic violence and we're dealing with housing in private housing, that can be a very difficult situation to try to counteract or to try to fight against, because we don't have the VAWA protections, the really good protections that we have under VAWA. We don't necessarily have the same protections in private housing or market rate housing. So now that said, One thing that has come about in recent years is the use of the Fair Housing Act to try to combat evictions of victims of domestic violence. So if we kind of harken back to law school, you may recall the Fair Housing Act, and if you talked about it at all, it applies broadly to almost all private housing throughout America. There's only a few exceptions, which we don't encounter all that often, but by and large, Fair Housing Act is going to apply to the vast majority of private housing situations. The current statute makes it illegal for a landlord to discriminate on the basis of these protected classes. And you see, I underline and highlight their sex. They can't discriminate on the basis of sex. And that becomes important because while a person's status as a domestic violence survivor or victim is not necessarily in and of itself a protected class, there are arguments and claims which can be made and have been made successfully by tying domestic violence to sex discrimination. And again, looping this back around what I talked about earlier, especially given that women are much more likely than men to be victimized by an intimate partner. I don't know the numbers anymore. You all may know very much better than I do, and maybe you put it in the chat even for my edification. I think the last that I'd heard, I think it was 7 or 8 out of 10 victims were female to male. I might be off on that, but again, by and large, female victims of domestic violence. And so that does pull in the possibility of arguing discrimination on the basis of sex. And that, again, keeping in mind that it can be intentional discrimination, which is disparate treatment, or it can also encompass disparate impact. And I do believe that a lot of these get brought under the disparate impact claims, if I'm not mistaken. And again, I'll harken you back to the NHLP's toolkit on this, which is found on the website that I linked to earlier, where they have a whole laundry list of all the cases nationwide where this argument's been utilized and utilized successfully, so that you can seek case examples if need be. Nuisance and crime-free ordinances have long been an issue. So for those who might not be aware, nuisance ordinances take several different forms. May be also referred to as disorderly or disruptive house laws or ordinances. They can take the form of fines levied against a tenant for perhaps utilizing police protection too frequently, and or they might require landlords to evict tenants in the face of there being some sort of nuisance, or the landlord might face losing his or her rental license. All of these, whatever form that they're in, all of these things have one thing in common, which is that when applied, they put the victims of domestic violence and stalking at grave risk of harm, either by forcing the victim to be evicted from otherwise stable housing, or by deterring the victim from accessing police protection when needed. I highlight as an example here something that's close to home here in PA, the Briggs versus Norristown case, which occurred several years back now. That involved the Pennsylvania ACLU, the Women's Rights Project, and then also the PCADV had filed an amicus brief in that case. In that case, there was a local 3 strikes ordinance threatening loss of police protection for a DV victim and also eviction of a DV victim. The end result was when the city of Norristown was sued, the end result was that there was a HUD conciliation agreement reached, wherein, amongst other things, the ordinance was repealed and damages were paid to the victim by Norristown. So these are can, especially in the context of domestic violence, are just horrible ordinances that potentially I suppose at least are meant well, but of course can have a terrible disparate impact on victims of domestic violence. So if you do happen to encounter them, I can't say for sure. I have not researched this terribly much here in recent years, but I feel like there's been enough litigation, especially with the Briggs case, and there's been litigation in other states around this. I feel that there's been enough litigation now that there's some good case law out there that stands for this proposition that if you do have a domestic violence situation and you're trying as a municipality or a city, a borough, what have you, if you're trying to enforce one of these ordinances, you're going to have a very difficult time as against a victim of domestic violence, because it's just horrific. And since then, we have the 2014 Act 200, And then the statute there that I've referenced, 53, section 304, which provides protections for domestic violence victims against penalties imposed by such ordinances. So there's been a lot of work done in and around this area to ensure that we have protections for victims of domestic violence as against these ordinances. Now, this is, even if you've been part of my prior year sessions, this is the one new slide in here. So again, I apologize if I bored you all to this point, if you've heard me go through the spiel before. But if you haven't, this is the new section. So there's a couple of recent rule changes that benefit victims of domestic violence in appeals from magisterial district courts or magisterial district judges. So these were changes that were made late last year by the Minor Court Rules Committee, and they took effect in January 1 of this year. There's several different rules that were amended. There was one that was actually created. I've just cited to a couple of them here, the couple most important ones, I think. And so again, this is when we're talking about dealing with the situation where a tenant, say victim, has a judgment entered against them and in favor of their landlord at the local magisterial district judge's office in the local magisterial district court, and they wish to appeal that judgment to the Court of Common Pleas to try to prevent the eviction from moving forward, the process from moving forward. Now, as a little bit of background for anybody who's not doing housing much or if at all, generally speaking, when a judgment's entered at an MDJ level in favor of a landlord and against a tenant outside of the DV context, any kind of general tenant has 10 days from the date of the judgment to file an appeal in the Court of Common Pleas if they want to challenge the possession portion of the judgment and stop the eviction. They have 30 days from the date of the judgment to file an appeal as to the money portion of the judgment, but that does not stop the eviction if that's all that you appeal. There's much more to that, but of course, for our purposes here, the big deal, I think, is just understanding that generally speaking, you've only got a 10-day window from the date of the judgment to try to stop the eviction. Otherwise, the eviction can happen within 11 days after the appeal period runs. So we hear frequently judges, when they're at hearings with tenants, they'll tell the tenant at the end of the hearing, if they enter a judgment, they say, hey, here's the judgment I'm entering this judgment against you. You have 21 days to be out. You've got 10 days to appeal, but if you don't appeal, you've got 21 days from today to be out. And they're saying that as a generalization because that's the process. You got your 10-day appeal period. There's an order for possession that gets issued as soon as potentially day 11 if you don't appeal, and you get 10 more days to be out. And on that 21st day, the eviction can commence. The constable comes out, physically removes the tenant from the property. So we have a summary eviction process here in PA. It doesn't take very long for a landlord to be able to get a tenant out here if they move through the process as quickly as they can. So that said, that as the backdrop to this. So now what happened here, and like I say, these recent enactments to protect victims of domestic violence is to provide a little bit more leeway there for victims of domestic violence if and when they have to file such appeals. So the first rule that they amended was in Rule 501 with the definitions section. They define a victim of domestic violence as a person who has obtained a protection from abuse order against another individual or can provide other evidence of abuse. So again, it is not an absolute necessity that the victim have obtained a PFA. I'm going to talk about an affidavit here in a second where they can self-certify and they can provide other evidence of abuse beyond a PFA. So Rule 514, then, that's what talks about the notice of judgment and what all that must contain in the notice of judgment. So now the notice of judgment shall include a notice that a tenant who is a victim of domestic violence has 30 days from the date of the entry of the judgment to appeal. And there's also filing instructions for asserting such an appeal. So this is a change. Every notice of judgment that gets sent out to tenants has this information on it. In 514.1, this is a new rule that they create a domestic violence affidavit. So kind of along the same vein as the self-certification form we talked about under VAWA, we have this domestic violence affidavit now, which is an AOPC form, Administrative Office Pennsylvania Court form. Once that form is completed, the affidavit's completed by the tenant victim. They file that at the MDJ's office first, and then they also file it along with their appeal in the Court of Common Pleas. When they file the affidavit at the MDJ's office, it automatically operates as a stay on the eviction process. So if the tenant had the tenant victim had the judgment entered against them, and they didn't know that they needed to appeal within the 10-day time frame, and again, the judge didn't know that they're a victim of domestic violence yet because they'd yet to fill out the affidavit, and the landlord ran in and got the order for possession. As soon as they fill out the affidavit and they get it into the MDJ's office, that puts a stop on the process. So even if there's an order for possession that says that the tenant's to be evicted the following day, that should put an automatic stay on the execution of that order for possession in the eviction process. And it's not a public record, and it can be challenged by the landlord, but it can only be challenged in the Court of Common Pleas through motion practice. And then Rule 1002 specifies that a victim of domestic violence has 30 days from the date of the judgment to file an appeal in the Court of Common Pleas. So this is even as to the possession portion of the judgment. So as I had mentioned before, as a backdrop to this, tenant usually only has those 10 days to appeal, but a victim of domestic violence has 30 days to appeal a judgment, even for possession. They just have to complete the domestic violence affidavit. And if you happen to be working with anybody in that circumstance, the advocate pointers are have them get that affidavit done immediately, have them get it to the MDJ office immediately, and then have them make sure that they're getting their appeal filed in Common Pleas, where they're also including their affidavit within 30 days from the date of the judgment. So that's a recent change, a pretty, from our perspective, there's not a whole lot of changes that get made in the area of housing and MDJ rules. So that's a pretty big change, and obviously very beneficial to victims of domestic violence. So I'm going to stop yapping myself, and I'm going to pull in Mary Beth, whom you'll find, I'm sure, infinitely more interesting than myself. And Mary Beth is going to tell us a good case that she and I had worked on a couple of years back. I have the kind of the details outlined here, but I'm going to let Mary Beth take over and go running through it. So Mary Beth, if you're there, I'll let you go ahead.
I am.
Thank you.
Thanks, Matt. Appreciate it. Good afternoon. I'm here today because 2 years ago, I was in attendance like all of you. And afterwards, I spoke to Matt about a case I had. We collaborated. Matt brought in another legal aid attorney, and together they helped me think beyond the usual, and really they broadened my view of what was possible to get the right result for that client.
Oh, I don't know. Did I freeze? Kelly, are you there? Did Mary Beth freeze, or is that me?
I think Mary Beth froze.
Oh, geez.
Talk to you today about one such case.
Sorry, Mary Beth, sorry. You froze on us. And I should have prefaced this with, I want everybody to know this. Mary Beth is currently on vacation and is taking time out from hanging on the beach and vacation to be here with us. So I can't believe I missed that. Thank you, Mary Beth. But sorry, I'll try to, if for some reason we do freeze again, I'll try to jump in. But sorry, Mary.
Okay.
Thanks.
So I'm here to talk about a case Matt and I collaborated on, because I too have attended this as a participant. And when I talked to Matt about the case he was willing to work with me to help the client get the right results. So I work at North Penn as a Judicare volunteer attorney, and I mainly do PFA work, but I often take unusual or more difficult cases, and this is one such case. So by way of background, we had tenants, a husband and a wife, who rented a home from a landlord. About a year after their lease started, my client, the wife of the tenants, was the victim of a horrific act of domestic violence by her husband at the house, which act was tape recorded on her 911 call. During the call, my client shot her husband in self-defense with a pellet gun, and he died. She was jailed and criminally charged, and the landlord knew she was in jail because this was all over the local news. In jail and unable to pay her next month's rent, my client asked family and friends to go to the house and get her belongings. The landlord prevented them from entering the property with threats of arrest for trespass. The landlord filed an eviction action in the Magisterial District Court, and the tenant was given notice in jail. She requested to attend, but the hearing fortuitously, for some reason, was scheduled for the same day as a hearing on her criminal charges. Without the tenant being present, the landlord was able to get a judgment for possession and for money damages, for unpaid rent, attorney's fees, and the costs of suit. Ultimately, months later, the client was released from jail and the court ruled her actions were taken in self-defense and the criminal charges were all dismissed. The tenant then came to North Penn Legal Services and asked us to assist her in trying to obtain her personal belongings that the landlord had either kept or disposed of. She wasn't even sure. Our position at Legal Services was that the landlord took affirmative actions to prevent the tenant's family and friends from taking possession of her things prior to her being evicted, which actions amounted to conversion of her property. Once we made the landlord aware of our intent to pursue affirmative claims for conversion, and we raised defenses to the landlord-tenant action, such as a failure of the landlord to credit a security deposit, the landlord agreed to settle. So a mutual release and settlement agreement was entered into, which agreed to the return of her possessions, which the landlord still had. But what was most important to me for the client was that the landlord agreed to withdraw the judgment so that no record of any claim against the tenant for unpaid rent would exist. Why was this so important? Because my client will likely be in a landlord-tenant relationship for the rest of her life. And to have this improper landlord-tenant judgment out there against her would be an impediment to her getting housing in the future. We all know landlords use the UJS system to do judgment searches, and then they refuse to rent to individuals who have had such judgments. So the landlord's attorney prepared a notice of settlement and a withdrawal of the judgment, which he then filed with the Magisterial District Court, which was accepted by that court and Mark received. And I kept checking the Pennsylvania UJS online portal for evidence of the withdrawal, and it never happened. Informally, the MDJ staff told me the problem was there was no drop down on their state court computerization system that allowed them to input a withdrawal once a judgment was entered. So their view is they couldn't do it. Officially, they wrote me and said that once the judgment is entered, it cannot be dismissed or withdrawn. No one has the legal authority to dismiss or withdraw. Only action is entry of satisfaction. An entry of satisfaction or a satisfaction of the judgment was not acceptable. To accept that would imply that the judgment was proper, and we wanted no impediment to this client obtaining housing in the future. And in essence, the settlement was an admission by the landlord that it was not a proper judgment. I then made an inquiry to the administrative office of the Pennsylvania courts. They admitted that the MDJ's office had reached out to them as well. Senior counsel there in AOPC's Information Technology Department, David Price, got back to me and said, look, file an appeal nunc pro tunc. And what that means is an appeal out of time. And let's see how we can move forward from there. So I came to a VOCA conference. And after hearing this presentation, I asked Matt what he thought, and Matt agreed that, the procedural wrangling of filing an appeal nunc pro tunc seemed the best next step. But we still had no idea how to wipe off that footprint of the case from the UJS system. So Matt in turn reached out to Dan Vitek from Community Justice Project, who sits on the state's Minor Court Rules Committee. And Matt and Dan helped me determine the next steps. They supported me throughout this process. They gave me forms of pleadings to use. And I followed their roadmap. First, we started with filing for the appeal nunc-pro-tunc, and then the appeal itself, and then trying to get rid of that landlord-tenant action by sealing it. And Dan, in addition, also offered to go to the AOPC on my behalf to request that if I could get an order to seal, that the case actually been sealed, because we didn't know if this was something they would be willing to do in an MDJ action. So the Landlords Council raised no objections, and this allowed us to move the process forward with consent. In the Court of Common Pleas, I filed my motion for leave to file an appeal nunc-pro-tunc, and it was granted. And then I was considering filing a I did file the traditional notice of appeal in the Court of Common Pleas, but because the landlord was cooperating with us, or his counsel was, Matt suggested that rather than going through the steps to get the judgment non-pros and then wait time and send notices, that we could get the same result with less steps if we just filed a stipulation of settlement, which we did. And with that stipulation, we filed an order that granted two aspects of relief. One, the judgment non-pros, and two, asking that the judgment entered by the MDJ in the underlying landlord-tenant action be placed under seal. And that was granted. But then we got to the point of, how do we actually make this happen? The prothonotary had no idea how to get a landlord-tenant action sealed. We served the order on the Magisterial District Court, and I gave notice to my contact at the AOPC that my guess is they would be getting phone calls with questions. And I got back an email that said the MDJ had already contacted them and that they do not expect there to be any issues. And a week later, the MDJ court called me and said, all evidence of the judgment is now gone. So there is no footprint here of the landlord's action against the tenant that exists. And that means we got the right result. But this never would have happened had I not asked for help, had Matt not jumped in, brought Dan, and that we walked through this together. And I think the lesson my case proves is that collaboration, creative thinking will get the right result for the client. And we should never accept less than what's the right result for the client. So thanks, Matt. Thanks for letting me share. And thanks for your help on my case.
Absolutely. Thank you for sharing. I cannot believe that you're on, but please go enjoy vacation, will you? I can't believe you are willing to do this, but thank you very much. And again, I will second that. Like, as I said up front, I'll say it again here as we're getting towards the end. I mean, honestly, you know, as I say, as I've gone through this with you all now, not that you're going to take a whole lot that you're going to remember from all this, but if nothing else, honestly, it's just you come across a housing situation, if it's something that you don't do frequently, by all means, just again, find a local advocate, or like I say, even if it's not a local advocate, you hit the listserv. And I've always found, as with probably, you know, most all different, you know, law groups, but definitely the housing law group is certainly, there's so many members who are willing to try to jump in and help as best as possible. So if nothing else, just recall that and try to take that with you here today. And Mary Beth, I don't know. I mean, for as long as I ever do this, I'm going to keep calling you like every year, and hopefully you won't be on vacation any other years. But I don't ever tire of hearing of that case and that story, because it was just awesome. So thank you again. So that I think about wraps us up here. I do have a resource listing here. Which these are all things that are, I think readily accessible throughout. And Plan has all this information. I have it and can share it if needed. Or these are things that I had pointed you to earlier, which is like the PCADV as a toolkit from back in 2013, which is, I think, if I remember, I don't know, 100 something pages perhaps of pretty much everything you could possibly need if you're trying to help a victim of domestic violence with housing issues. The aforementioned Housing Law Project websites. We have the Hud Notices. Those are the two most important Hud Notices when it comes to VAWA and its implementation for subsidized housing. Congressional Research did a memo. Congressional Research Service did a memo about like historical overview, funding, reauthorizations, et cetera, and then DV in the context of COVID-19 as well. These are all good resources. And again, if need be, feel free to reach out to me. I can try to provide those if necessary. Last thing I've got is just my accountability slide with all my contact information on there. You can feel free to reach out to me at any point. I don't promise at all to ever have all of the answers, but at the very least, I will try to find somebody who knows what they're talking about and try to get you answers as best as I can. So I think, Kelly, I know we're a little early here, and I don't know if we're allowed to be early. I had answered a couple of questions that were in the chat as Mary Beth was telling her great story. And
I'm going to go ahead and launch the second CLE poll box. I will leave it up for 2 minutes. So attorneys that want CLE credit, please respond. I'm seeing that there's a few new postings in the chat box. So is there
I think they were
anything
all
that you,
great works and
oh, okay.
et cetera. And
So
thank you to you all.
You got to address Victoria's
I did.
question or comment?
Yes. Anybody else? I mean, and I think this is the point now where if anybody wants to come off of mute, you don't want to type in the chat box. I am done going on and on here and droning. So we've got a couple of minutes here. I am certainly able and willing to stick around here and see if there's any other questions or if anybody wants to talk through anything.
Okay, so you should be able to unmute yourselves, anyone. So anyone with comments, questions, anything, just hit unmute and you can speak. Or if your preference is to put it in the chat box, please go ahead and do that. We'll give you about 20 seconds, see if we get anything in here. And if not, we will end a little early today. So Mary Beth can go back to her vacation.
Yes, I will. I have one note here if we don't get any questions, something I just think for one of the things that if you're working with victims of domestic violence that you're likely to encounter that is a very tricky situation that we do see pretty frequently, unfortunately, is the scenario where you have the victim who has moved in with the abuser, and the abuser either owns the home or is the tenant who is renting the property from the actual owner or landlord. And then by way of the PFA, the actual either the owner, the abuser owner or the abuser tenant is removed from the property. And now you have this situation where the victim is in the property but doesn't necessarily have a right to remain in the property. Those are very difficult situations to deal with. To the extent that you do encounter those, again, there's not an awful lot that can necessarily be done there, but I do think that if you encounter that, try and reach out to somebody who might have some experience with those and can try to help you through them. I do see a couple of questions here coming in, and Kelly, I'll try to roll through them. So, can a victim file for VAWA while living with the abuser and currently married with no plans of divorce? As I understand it, yes. The VAWA protections can be utilized even if they are living with the individual. For instance, I'll just use it as an example. We had talked about like the public housing scenario or the Section 8 scenario where the victim is listed on the lease, but the head of household is the abuser. So in that situation, they can utilize, because again, VAWA covers every member of the household. So even though they're not the head of the household, they can request protections under VAWA. And in that scenario, they might bifurcate the lease. They might potentially remove the abuser depending on the circumstances, or they might potentially give a voucher to both the victim and the abuser to allow the victim to look to move elsewhere. They might, because of their emergency plan, they might look to bifurcate the lease and move the victim into a different lease and then make the victim the head of household at the new unit. So yes, there aren't any requirements that they, be married or separated or have any plans of divorce or what have you. And then Victoria, any mortgage foreclosure protections available? I am not aware of any. I will readily admit that I'm probably not the best to answer that because I don't do an awful lot of mortgage foreclosure work. So there might be something going on there that I don't know about. My suggestion on that would be that I know, like on the Plan Housing listserv, if you want to post that to the housing listserv, I know we've got a number of advocates who do a lot of mortgage foreclosure work who are on the housing listserv. And you might check in with them if you have a scenario where you want to see if there's any mortgage foreclosure protections available, but just none that I'm aware of offhand. Sorry.
Okay,
All right, I
well,
think
that
that's
looks
it,
like
Kelly.
it's it.
Thank
Thank you
you.
so much, Matt and Mary Beth, for being with us. And everybody enjoy the rest of your day. We'll see you tomorrow at 11 o'clock for the next VOCA session. Domestic violence and elderly issues is tomorrow. So thanks, everyone. Take care.
Thanks.
Thanks, Kelly. And thank you again, Mary Beth. Can't thank you
Thanks,
enough.
Matt.
Really
Thanks,
appreciate
Kelly.
it. Take care. Enjoy vacation.
Thanks.
We'll see you.